The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Good afternoon. I understand that based on the dissenting opinion as well as the grant of the appellee's petition for discretionary review, that you have both determined what time allotments will be given for each parts of your argument. Based on that, I will encourage you to keep your own time. Both sides are given 30 minutes, and both sides will have a 2-minute warning. That is 2 minutes would be all that would be left on your entire argument. So that being said, the case is Griffin versus Absolute Fire Control et al., and we will hear from the appellant.
May it please the court. Good afternoon, Your Honor. My name is Demetrius Berry, and I represent Absolute Fire Control and Everest National Insurance Company in this case. I would like to reserve 10 minutes of my time for purposes of rebuttal and to respond to the plaintiff's appeal. By this appeal, Everest and Absolute Fire Control seek reversal of the North Carolina Court of Appeals decision as to the issues of futility and suitability, because there was competent evidence in the record to support the findings of fact by the commission, and the findings of fact support the conclusions of law. I would like to look briefly at the pertinent facts. Mr. Griffin was hired by Absolute Fire Control in 2007. In 2014, on October 23rd, he sustained an injury to his back and to his ribs. He was out of work completely for 4 weeks. He was able to return back to work with restrictions on November 24th. November 24th. That's correct. His restrictions consisted primarily of no lifting above 20 pounds. He was originally hired as a pipe fitter. The restrictions would not allow him to return back to work as a pipe fitter, so Absolute Fire Control offered him a job in the fabrication shop. He worked in the fabrication shop for almost 2 years when on August 2016, he underwent heart surgery, which was unrelated to any work accident. He returned back to work after the heart surgery in November 2016. However, Mr. Griffin specifically requested to go back to work in the field instead of working in the fabrication shop. Absolute Fire Control accommodated his request to work in the field. And despite working in the fabrication shop for 2 years and working for Absolute Fire Control, even to this day, Mr. Griffin filed a request for hearing before the commission seeking a determination as to whether he was disabled and as to whether the work offered by Absolute Fire constituted suitable employment. At the full commission level, the majority opinion made a decision that Mr. Griffin was not disabled, that he failed to meet his burden, and also found that the job of the fabrication shop in the loose material area constituted suitable employment. There was also a dissent at the full commission level, but only as to the issue of suitability. The plaintiff filed an appeal to the North Carolina Appeals, and at the appellate level, the appeals court affirmed the Industrial Commission's decision as to the fact that Mr. Griffin failed to conduct a reasonable job search. So that was affirmed. However, as to the issue of futility, the Court of Appeals reversed and remanded for further findings. Also, as to the issue of suitability, the Court of Appeals remanded for additional findings. There was a dissent by Judge Tyson at the Court of Appeals level, and Judge Tyson concluded that there was no reason to remand on any of the issues if the court had followed the appropriate standard of review. He indicated in his dissent that there was competent evidence to support all findings of fact by the commission, and we certainly agree with the analysis set forth in the dissent in this matter. First, I want to look at what the standard of review is. It has been long established that the Court of Appeals is limited to, first, whether there is competent evidence that supports the commission's findings of fact, and second, whether the findings support the commission's conclusions of law. At the appellate level, the findings of fact by the commission are considered binding and conclusive if supported by competent evidence, even if there is contrary evidence in the record to state otherwise. The defendants believe in this case that the Court of Appeals abandoned the appropriate standard of review as to the issues of futility and suitability and exceeded its scope by reweighing the evidence and also placing a burden on defendants. First, I want to look at the issue of futility.
Before you do that, let me ask you just a quick question about the findings and conclusions. My understanding of the Court of Appeals opinion majority is that the majority thought that the findings were supported as far as they went, but that additional findings needed to be made on suitability and futility, and that some of the findings might have been conclusions of law that are reviewable. Is that consistent with your reading of the opinion?
That is consistent as to the issue of suitability, but I do believe the Court of Appeals reversed as to the issue of futility. And that is the finding of fact number 37 that the Court of Appeals relabeled as a conclusion of law as opposed to a finding of fact to support their position. But on both issues, they decided that additional findings were necessary. But as to futility, they specifically reversed that one issue, if I recall the decision correctly, Your Honor.
Okay, thank you. Go ahead. I don't want to interrupt your flow too much.
No problem. Thank you for the question. Looking at the issue of futility, that is one of the factors that was set forth in the Court of Appeals decision of Russell as one of the ways that an employee may prove disability. And essentially, the employee has to show that he is capable of some work, but due to pre-existing conditions, it will be futile or pointless for him to actually search for work. In this case, the commission found at finding of fact number 37, in part that the plaintiff did not show that it would be futile due to pre-existing factors to search for work. And the burden of proof is on plaintiff to show that. And we believe that there's competent evidence in the record when you review the record that was before the full commission. Looking at the supplemental record on page 139.
I'm sorry to interrupt you again, but it looks like the majority says that the commission's conclusion that there was no evidence to support plaintiff's claim of futility reflects a misapplication of the governing precedent and is undermined by its own findings. So it thought that additional addressing of that issue was required, as I understand it.
Yes, Your Honor. And the way I understand it is they got to that conclusion by first relabeling finding of fact number 37 as a conclusion of law. And so if you look at finding of fact 37 as a finding of fact, the question is whether or not there's competent evidence in the record to support that finding by the commission. And if you look at the supplemental record on page 139, when asked whether or not Mr. Griffin looked for any work, he specifically stated he had not looked for any work because he liked the job that he was doing. He liked the employer that he was working for. Even when asked on direct by plaintiff's counsel whether or not he thought he could find any work, the response on the record on page 132 by Mr. Griffin was not if it was something where I had to lift above 20 pounds. Out of the entire record, that is the only answer or response by Mr. Griffin as to whether or not he could do work or whether or not he could look for work. So when the conclusion of law stated that there is no evidence, we believe that's supported by the competent evidence in the record because Mr. Griffin failed to make any connection as to any pre-existing conditions that would make it pointless for him to look for work. Now, the full Court of Appeals made a point of saying that the full commission made a finding of fact as to how old Mr. Griffin was, as to his level of education, and as to his work experience. And the defendants will contend if you look at almost any decision by the full commission, you will see those findings. That is typically done. But the mere fact that
Ms. Berry, is there a difference for purposes of workers' compensation law and practice between a statement in the commission order that says that there is no evidence of something as compared to we do not, after reviewing the evidence in light of the applicable standard of proof, believe something?
I would say just that those two statements are one and the same, and I'm not aware of any appellate law or statute that would require the full commission to say specifically no evidence, as opposed to we do not believe there's any evidence to support a position.
The reason I ask that is because it's even to a layperson who never appeared in the commission proceeding, to say that there is no evidence of something suggests that we've looked at the record and there's just nothing there from which you could find it even if we elected to believe it. Whereas if you simply find that something isn't so, that the former doesn't seem to me to involve a credibility judgment. The second sounds to me as if it does. If you disagree with that, tell me, help me understand why.
Justice Irwin, I would say that the full commission is the sole judge of the weight of the evidence and the credibility of the evidence. And if you look at that standard, I would say the full commission can look at a record and say there's no evidence to support a certain legal principle. In this case, futility. There's nowhere in the record where the plaintiff made any connection, any explanation, or any reason as to why it would be futile for him to look for work because of any pre-existing condition he had. He testified at the hearing that prior to the accident on October 23rd, that he was a healthy individual. So there's nothing there in terms of a pre-existing physical or mental limitation before this work injury. He was 49 years of age. There's no evidence that because he was 49, it will be futile for him to look for work. There's also evidence in the record that he had attended grade on level to the 10th grade. Again, there's nothing in the record to show that because he attended the 10th grade level, that it will be futile for him to look for work within his restrictions. And then the final thing is looking at his experience. He testified that he had primarily worked in construction, building houses, and also in the record, there's evidence that he also worked in the maintenance department, as indicated in the plaintiff's brief. So just merely looking at what he testified to, he never made any connection, any explanation to say that because of these factors, it would be pointless for me to look for work. His testimony was, I didn't look for work because I like the work that I'm doing. I like
Do you understand the the Court of Appeals majority's decision with respect to the futility issue to leave it open to the commission which way to decide the futility question on remand, or do you view the majority's decision in mandating a particular decision with respect to that issue?
Well, I look at it both ways. And on the one hand, they say they reversed the futility argument, which seemed to indicate that they reweighed the evidence and said that the full commission was wrong. But they also said that the full commission needed to make further findings as to futility. If they had solely said, fine, make further findings, then it would have been open to the full commission to look in the record or to write the opinion award such that it's specific as to why there was no evidence. So because they said reverse, it seemed to indicate that they thought the full commission did something wrong and they attempted to reweigh the evidence.
Let me
I'm sorry, what were you about to say?
I had a question. I wanted to back up just a second and ask you about finding what is denominated finding of fact number 37, which has the first sentence and the last sentence both indicate that the plaintiff has not proved he is disabled. And my question is, isn't disability sort of a core concept of law under the Workers' Comp Act that's defined in the statute?
Yes, Your Honor, I would agree with that disability is a core concept. The burden is on the plaintiff. But in this finding of fact, they set forth several factors as to why they believe the plaintiff had not met his burden. So I would say that it is a finding of fact in number 37 that they set forth. If you look at it, it says number one, that the plaintiff was able to earn his pre-injury wages. That's not a conclusion of law. That's a finding of fact. It also said that there was a suitable position within his permanent restrictions. So again, that's a finding of fact by the full commission, and that none of his treating physicians have removed him from work in the employment. And then it goes on to say that he hadn't made a reasonable job search. And finally, that he had not shown that it would be futile due to pre-existing conditions. So they seem to list several factors in that finding of fact.
It seems as if that at a minimum, number 37 is mixed, that there are some factual issues that go to the core legal issue of disability. And if that's the case, if we think that that's the case, and I'm not trying to second guess anybody, but would you agree that if it's a mixed question of law and fact, that is something that's reviewable? de novo?
If it is a conclusion of law, then I would agree it is reviewable de novo. And that's what the Court of Appeals did. It changed the label of number 37 to make it a conclusion of law in order to support the analysis they made in reweighing the evidence and shifting the burden. But if you simply look at the finding of fact number 37 as is and determine whether or not there's any competent evidence in the record to support it, then under the standard of review, the finding of fact would be binding, it's unchallenged, and it should be conclusive. And finding of fact 37 supports the conclusion of law that there was no evidence as to futility, Your Honor.
Okay.
As to the issue of futility, the main point that has to be looked at is whether or not the plaintiff made any connection. Just merely listing data is not sufficient to show that there is evidence of futility. So we believe in this case, as the full commission and dissenting opinion found, that Mr. Griffin did not meet that burden. Looking at the issue of suitability, the question there again was whether or not there's competent evidence to support the commission findings of fact. If you look at the findings of fact number 32 and 33, the defendants believe there is sufficient evidence in the record to support those two findings. What the Industrial Commission found was that the fabrication shop job was not specifically created for plaintiff, that he was able to do the work within his restrictions, that the fabrication job provided the same hours, and that the fabrication job provided the same wages as his pre-existing injury position, and that the fabrication shop job was essential to the operation of absolute fire control.
Well, don't our precedents, particularly Peoples and Psalms, indicate that that the key inquiry is not whether the job is key to the employer's operation, but the essential inquiry is whether it's available out there in the competitive marketplace and whether some other employer would hire the plaintiff to do a job like that.
Justice Hudson, the defendants would argue, if you look at Peebles, Psalm, and Smith, they all go to the principle of open competitive employment only if there's first a finding that the job was specifically created for the employee. That was the case in Peebles, where they took the individual from the supply room, from the car room to the supply room, allowed him the same wages that he made as a supervisor, allowed him to come and go as he wanted to, they paid him even if he worked or didn't work. And there was no one else that they could point to that performed that same type of work. So the court decided that that job was specifically designed or tailored for Mr. Peebles. So then you had to look to see, was that job available within the open market? The same thing in Psalm with the housekeeper. They specifically created a new position of quality control. There was nobody else that had worked in that position, and it was the testimony of the supervisor in that case that this position was created for this employee. So because it was specifically tailored for the employee, then you have to make the analysis to see whether or not that job is available within the open market. The same thing in the case of Smith, where it was a bailer position that was created, where previously there were multiple individuals that did that job, but once the employee was injured, they then created the bailer position specifically for that employee. That's not the case if you look here in this decision. There's evidence that that job existed before Mr. Griffin went to work in that position. There's evidence that other people were working in the same position at the same time he was working, and the testimony at the hearing was that that position was still available and others were still working there. So it was not a job that was specifically tailored or created for Mr. Griffin. The only thing
wasn't there also testimony that the job was a light duty job that had was consistent with Mr. Griffin's 20-pound lifting restrictions, and that that somebody off the street probably wouldn't be looked at even for.
You're correct, Justice Hudson. There was a question that was asked if, I'm sorry, there was a delay. I didn't mean to speak over you. There was a question that was asked is if somebody had 20-pound lifting restrictions off the street, would they be hired? And the employer did say, off the street, no, we hire based upon word of mouth and recommendations. This is the place that they testified that they had never advertised any jobs. They had never listed anything in the newspaper, that they did their hiring based upon word of mouth and recommendation. So without a word of mouth recommendation, someone with 20 pounds more likely than not may have been disqualified from that job, but not simply because of the 20 pounds, but because of their hiring practices. And so that one.
Well, wouldn't you agree that the key question about the job is whether it represents accurately the plaintiff's wage earning capacity in the competitive marketplace?
I do agree, Your Honor. We believe the job shows that Mr. Griffin was able to go back to work in the fabrication shop earning the same wage at $18 an hour. There's testimony that individuals that worked in that area outside Mr. Griffin earned anywhere from $10 to $25 an hour.
Right.
So they didn't create a different wage. I'm sorry.
Well, the Court of Appeals focused on the fact that that the full commission didn't address the aspect of the job about whether it was available by another employer. And that's the part that Psalms talks about specifically. And that says if the proffered employment does not accurately reflect the person's ability to compete with others for wages, it cannot be considered evidence of earning capacity. And that proffered employment would not accurately reflect earning capacity if other employers would not hire the employee with the employee's limitations at a comparable wage level. So that's an opinion from this court saying that that's what has to be shown for it to be evidence of wage earning capacity. And as I understand it, that's the part that the Court of Appeals said had not been adequately addressed by the full commission. So whether or not you think that it should be, would you agree that that's the part that the Court of Appeals says the full commission needs to address?
I do agree that's the part that the full commission said should be addressed, but in each of those decisions, Psalms, Smith, and Peebles, you do not get to that analysis. It is not triggered until there's a finding that the job was specifically created for the employee. In our case, the job was not specifically created for Mr. Griffin, so there's no need to get to that analysis as to the open competitive market. I see that my time has already expired. I'm into my rebuttal time. So unless there's additional questions, I will reserve the time that I have left. Thank you so much.
Thank you, counsel. We'll hear from the appellee. You may want to unmute.
Thank you, Your Honors. Sorry for that oversight. May it please the court, Chief Justice Newby, Associate Justices in the North Carolina Supreme Court. I'm Christian Ayers, and I represent Mr. Griffin, the employee appellee. This case is about how disability determinations are made. The law as established in this court in Peoples versus Cone Mills directs the Industrial Commission to consider age, education, prior work experience, and other pre-existing conditions when it determines disability. The Court of Appeals correctly held the Industrial Commission did not take those considerations into account, and therefore the majority opinion should be affirmed. We are not seeking a declaration of permanent disability here, nor would Mr. Griffin want it. We contend, and the record supports, that Mr. Griffin is temporarily disabled until such time as he's offered the means to overcome that temporary disability. Mr. Griffin is temporarily disabled as a result of his 9th grade education. His only work experience in heavy-duty jobs such as construction and pipe fitting, which do not create transferable skills for a light-duty job. His age of 53, and more importantly, his significant limitations, including the need to leave work at will due to pain, and his physical limitations suffered in an on-the-job injury that prevent him from doing the jobs that he's experienced in. Mr. Griffin is temporarily disabled despite the fact that Mr. Griffin was working at the time of hearing. What this case was meant to do is affirmatively address the inherent danger that is created when make-work jobs provide a false sense of earning capacity. I'm here now because the appearance of false wage earning capacity can harm people like Mr. Griffin down the road if they're held up from vocational rehabilitation because they're working a make-work job. The employer's efforts are appreciated, but the job insecurity that comes from a lack of wage earning capacity is very dangerous to Mr. Griffin. The danger is, should the employer go out of business, or as Mr. Griffin reported to his doctor on record supplement page 405, that the employer told him he cannot continue to employ him on a permanent basis at light duty, Mr. Griffin will be left with no earning capacity. But even more damaging, he will be denied the tools needed to regain that earning capacity. And that's why we're here. For the reasons that Chairman of the Industrial Commission, Philip Bedore, wrote a lengthy dissenting opinion at the full commission level, and for the reasons the Court of Appeal reversed and remanded this matter to the Industrial Commission for further findings, Mr. Griffin urges this court to affirm the Court of Appeals reversal and remand regarding the clear futility. Yes, Your Honor.
Let me jump in and ask you about how would you characterize finding what is denominated finding of fact 37? We had a discussion about it, your colleague and I just wondered how you would characterize that particular paragraph.
That's an excellent question, Your Honor. Finding of fact 37 addresses the heart of the disability determination. And it's long been the law of this court since for over 40 years. The determination of whether disability exists is a conclusion of law. This is stated as clear as possible in Lanning versus Fieldcrest, a Supreme Court case. Hilliard versus Apex Cabinet Company, also a Supreme Court case. So the disability question, which finding of fact 37, it seems to address, is a conclusion of law that must be based on findings of fact and supported by confident evidence. So, yes, Your Honor.
I was just going to follow up and ask you about how you would characterize the rest of that paragraph. Do you think that it's a mixed finding and conclusion, or that it's reviewable because it's mostly a conclusion of law, or?
But it is fully reviewable, Your Honor, and the reason is any statement of a finding of fact in finding of fact 37 directly addresses the question at issue, which is a conclusion of law. I think at worst case, it is a mixed finding of fact and conclusion of law, which would still be reviewable de novo. However, the legal analysis required to determine disability, as the Industrial Commission purported to do in finding of fact 37, it requires judicial reasoning. It requires applying the law of this court to the facts of the case. It is, therefore, a determination of disability and a conclusion of law, which is subject to de novo review. And as you're familiar with, this court does review conclusions of law de novo, and under a de novo standard of review, the Court of Appeals below as well considers the matter anew and can freely substitute its own judgment for the judgment of the trial court. So the Court of Appeals, in looking at the factors here, Mr. Griffin, his doctor advised need to leave work some days due to pain. That's record page 67, finding of fact 21 of the Industrial Commission. He needs to leave work some days at will because of his pain. His age of 53, his 9th grade education, those are in finding of fact 1. His only experience in heavy duty jobs such as construction, pipe fitting, and his restrictions to no lifting more than 20 pounds, no bending, which actually the testimony of record shows that the job defendants have held up as suitable employment requires bending, and to alternate sitting and standing. Plus, and this is very interesting about this case, Mr. Griffin, when he reported that his employer could not continue to employ him on a permanent basis at light duty to his doctor said, well, let's get you vocational rehabilitation. That was also a finding of fact. In finding of fact 15 and 16, vocational rehabilitation was recommended and it was not given. All of these facts, as found by the Industrial Commission, they show it's futile for him to try to go and find work that he's capable of, particularly in light of the need for vocational rehabilitation his doctor assigned.
Let me ask you about your reaction, if any, to your opposing counsel's read of Psalms as requiring, as I understand Psalms and Peoples, there's a requirement under our law that a job created by the employer for the injured employee doesn't doesn't show his wage earning capacity unless it's also shown that some other employer would hire the plaintiff to do that job. Do you understand those decisions as being dependent on a showing that the job was specially created for the plaintiff?
No, Your Honor, though we could make that showing here, but to address that point, I would direct the court's attention to this court's own case of Peoples versus Cone Mills. In that case, the court pretty clearly stated that the proffered employment would not accurately, and I want to get the language correct here, the proffered employment would not accurately reflect earning capacity if other employers, and it specifically uses the words other employers, would not hire the employee with employees' limitations at a comparable wage level. It's particularly revealing that in finding of fact 21, the full commission found that Mr. Griffin's going to have to leave work due to pain some days. And it strikes me that alone is pretty convincing that other employers would not hire this individual if he just has to up and leave due to pain. I cannot think of too many jobs where that would be the case. Certainly, this employer's willingness to accommodate that is commendable. But Peoples says many times over that we can't leave this the employee's well-being, his wage earning capacity, to the sympathy of the employer. There needs to be some evidence, and the Court of Appeals correctly reversed and remanded the full commission on this matter, that the job is reflective of that employee's ability to go find work at other employers. Because without that, there is job insecurity for Mr. Griffin. His job.
And I wanted to ask you about that. That's consistent with my understanding. But in cases like this, and in Peoples and Psalms, where the employer is trying hard to accommodate the employee and bring them back to work after they've gotten injured, that this court has gone to some lengths to explain that doesn't necessarily reflect their wage earning capacity in the general marketplace, and that's what you have to show to decide if you're really disabled and within the meaning of the Workers' Comp Act. That there's an extra protection because of the vulnerability by an injured employee, no matter how hard this particular employer is trying to do the right thing. And it looks like both the employer and the employee here were trying to do right, but am I missing something there?
No, Your Honor, that's 100% correct. That the main concern is that this employer may be trying to do the right thing, and they certainly are here. But the economy can change. They can go out of business for reasons that are beyond their control. That's a factor that this court has looked at. And so Mr. Griffin's ability to put food on the table for his family at this point, we would contend, is solely dependent on Absolute's extension of this job. And if it is true, as Mr. Griffin was led to believe, that his employer cannot continue to employ him on a permanent basis at light duty, if it's true, as the vice president testified, that if someone in Mr. Stacy Griffin's position here, only being able to lift 20 pounds, applied for a job in the loose material side, would that discount him from that job? And he says, yes, it probably would. If this job goes away, Mr. Griffin is out of luck. And
well, let me ask you something about you mentioned the vocational rehabilitation services. And now this is an accepted claim, as I understand it. And Mr. Griffin has gotten a 10% rating, and he may have loss of wage earning capacity. So he's entitled to whichever of the types of benefits is most favorable to him. He gets to make that choice, correct?
Correct, Your Honor.
And so as part of the ongoing management of his workers' comp case, would he still be able to utilize vocational rehabilitation services and attempt to sort of better his condition to get a job out in the marketplace?
Yes, Your Honor. Vocational rehabilitation is provided for in NC General Statute 9732.2, and it specifically provides that if an employee has a loss of wage earning capacity, and I believe it's if he's lost more than 75% of his wage earning capacity, he is entitled to vocational rehabilitation. So if the full commission on remand were to find that Mr. Griffin is disabled, that it's futile for him to go out and find work because of these factors, certainly chief among them that he is going to have to leave whatever job he obtains at random because of his pain, the employer can then offer the doctor recommended vocational rehabilitation. The law recognizes that someone like Mr. Griffin, 9th grade educated, only done the same type of work his entire life, heavy duty jobs, construction, pipe fitting. He is not going to be equipped to do a job search that's going to be successful. He's not equipped to go out there, put him out there and find the right type of work that's going to fit within these pretty rigorous restrictions. The man can't bend. He cannot just work an 8-hour shift and be there as the employer needs him to be without some risk that he's going to have to leave that day. Sorry, Your Honor, did I hear someone?
I unmuted, but I was waiting for you to finish your statement.
Oh, that's okay, Your Honor. I'd like to address your question.
Well, I wanted to ask you basically the same thing that Justice Hudson broached earlier with respect to with your colleague. What is your sense of what the upshot of the Court of Appeals majority decision is? What happens assuming it remains undisturbed?
Your Honor, what the reversal and remand we take to mean is that the full commission stated pretty clearly, I mean, it was explicit, they found no evidence of futility. So what the Court of Appeals is trying to correct here.
And this was something I discussed with colleagues as well. Do you see a difference between a finding that there is no evidence of something and a finding that something is or is not actually the case?
Yes, we do, Your Honor. And the reason is, in order for this court and the Court of Appeals below to be able to review opinion, they have to look at what the full commission states in their order, specifically with regard to their conclusion of disability or no disability. And here, the full commission was clear. They stated there was no evidence presented. However, the Court of Appeals correctly recognized that under de novo standard of review, they can see there was evidence of age and experience, lack of education. There were these other factors that he needs to leave work due to pain, that he hasn't received vocational rehabilitation. These are all factors which this court and the Court of Appeals below have considered in passing on futility by for proving disability.
At least it's my tentative reading, subject to all the caveats I gave when I was discussing the subject with Ms. Berry, that the effect of this part of the court's decision, the Court of Appeals majority decision, is to say, in effect, the finding that there is no evidence of which you could find futility is unsupported by the record. Here are these findings that might support futility. We remand it to you to make appropriate findings. So am I correct in reading this decision, at least from your point of view, to leave open the question of whether your client has in fact satisfied what before some of this court's recent decisions we might have more confidently referred to as the third prong of Russell, open for review one way or the other by the court, by the commission, based on proper findings?
That is correct, Your Honor. I would say that at worst for my client's case, the full commission would be able to still consider whether Mr. Griffin is actually disabled based on these factors. But the law of this court is pretty clear. where the commission acts under a misapprehension of law, which is what the Court of Appeals has found correctly or concluded correctly, the full commission did here. The award.
And so the effect of that would be to say, go to the commission, revisit the issue of whether my client has established disability on the basis of the third prong of Russell, based on a proper understanding of what is and isn't relevant to making that decision. Is that what the upshot of it is, you see it?
That's correct, Your Honor. The award must be set aside and remanded for a new determination using the correct legal standard. So
it's not a preordained conclusion one way or the other as to what will be decided on.
No, Your Honor. No, the Court of Appeals has not dictated to the full commission that they must find he's disabled because he showed futility. Merely that the conclusion of the full commission that there was no evidence on the factors presented can't be sustained on the record. It's
okay. What about the third issue with respect to suitability? I remember discussing this with Ms. Berry, and she was not quite clear in her own mind, I think, as to, she could correct me if I'm wrong, if I'm misstating what she's told me in response to my question, but I understood her to say that on the one hand, it looked like the Court of Appeals seemed to find that there was the fabrication shop position was not suitable employment, but then on the other hand, they remanded the case for further findings with respect to the suitability of that position, which would tend to suggest that the commission had the right to revisit that issue in light of a proper understanding of the law and come out either way. What is your view of the upshot of the Court of Appeals decision with respect to the suitability issue?
Yes, Your Honor. I do, to some extent, agree that the full commission will be able to make their own determination once they make the appropriate factual finding. And what's so important about the Court of Appeals decision here is that they found, or they concluded, the full commission did not consider the central tenet of the suitable employment question, which is whether this employment is available at other employers. The full commission essentially looked at this employer, said, okay, great, it exists at this employer, therefore it must exist everywhere. That reasoning is not supported by the Supreme Court or the many years of case law in this area.
Let me just ask a quick follow-up on that. And am I correct that what the upshot of the Court of Appeals opinion is to send it back for the full commission to readdress the disability issue, i.e. futility, and how that fits in? And second, the central tenet, as you put, of the whether the job shows wage earning capacity by seeing if it's available from other employees, the peoples and Psalms aspect of it. And with those two things, that the commission can come to whatever conclusion it comes to after it addresses those aspects. That
is correct, Your Honor, so long as they make their determinations, their findings of fact within the lens of the correct law. The award must be set aside and remanded, as the Court of Appeals did, for a new determination using the correct legal standard. That would be the caveat. Okay,
but it doesn't tell them how to come out.
No, Your Honor.
Okay, I just wanted to be clear about that. Thanks.
Yes, thank you. I do want to just briefly alert the court to a issue that touches on the suitable employment. The dissent did not make suitable employment a basis for his dissent. And further, the defendant appellants did not notice this as an issue in their notice of appeal. They have briefed it, and I have responded to that issue in my brief. I do think we are correct on the merits, but I would alert the justices to Rule 16B of the North Carolina Rules of Appellate Procedure, which requires both of those things in order for this court to have that issue properly before it. I would just briefly stay on the merits of suitable employment. Were this court to reach it, though I do believe Rule 16B precludes that, that the evidence is pretty compelling in the record that the full commission did not consider other employers, whether this job would be available at other employers. If the court does review Chairman of the Industrial Commission Bedore's dissent at record page 80, he would actually disagree with the premise. He would have held there's no evidence of record to support the findings that Mr. Griffin's job was permanent, available in the marketplace, and not specifically tailored to Mr. Griffin. And that's pretty strong wording there. With regard to the actual job that Mr. Griffin was offered, the loose materials side job, there were 1 or 2 employees that worked this job. Mr. Griffin, and then an individual who was there before him, which left. When that individual left, and I'm talking about record supplement page 149 and 150 now. When that employee left, Mr. Griffin, the spare employee, was not put in that position. Mr. Carlton, another employee, left another area of the shop and came to fill that position. Mr. Griffin, if he had been able to do that work, presumably could have filled that position, but he was not put in it. The employer testified their need was for a driver, not for Mr. Griffin's position, not for the loose materials side job. Most importantly, Mr. Griffin testified he can't find this work anywhere else. Defendant appellants cited to that on record supplement page 132. I do want to raise the issue that's before this court on the petition for discretionary review. I recognize I'll go into some time in my rebuttal, but I think it's worthwhile. This court in Wilkes, a recent Supreme Court case, stated that the commission must take into account age, education, and prior work experience, as well as pre-existing and coexisting conditions when determining the loss of wage earning capacity. This is important. It does not stem just to the argument of futility, whether it was futile for Mr. Griffin to go out and find work. It encompasses the whole question of disability. The full commission below in the Court of Appeals properly reversed and remanded this for the Industrial Commission's failure to consider age, education, and experience with regard to the futility. The Court of Appeals should have also reversed and remanded the determination of whether Mr. Griffin made reasonable efforts to find suitable employment, because the full commission did not consider those same factors when ruling on that determination of disability.
Let me ask you real quick about that. You mentioned that this court discussed it recently in Wilkes, but it's not a new concept. In Wilkes, we went to some length to go back to its origin in the statute in 97-2 sub 9, and also as far as Hilliard and a number of other cases, that concept of those factors need to be considered by the commission is not new with Wilkes. We just summed them up then.
No, Your Honor, that's correct. And you cut out for a minute, so I apologize if I don't address every bit of your question there, but you are correct.
That's right. You probably heard all that you needed to hear.
Wilkes puts it in forceful language that the Industrial Commission must consider. The Industrial Commission did not do so here with regard to either the reasonableness of Mr. Griffin's job search, especially in light of his lack of vocational rehabilitation, something his doctor said this guy needs. Mr. Griffin needs this, and that plus his age, his experience in prior work that was heavy duty jobs, his only 9th grade education, he doesn't even have a high school degree or a GED. All of these things should also bear on the Industrial Commission's determination of whether this employee is doing a reasonable job search, or, well, it's not even a reasonable job search, a reasonable effort to obtain suitable employment. That's what the law says. That's in Medlin and Russell. Here, Mr. Griffin, he's working a job that he doesn't believe is a real job, but he also testifies he doesn't think he can go out and get a job with his restrictions. So these factors that Wilkes said and Peoples before it that we must consider we contend the Industrial Commission should have considered those factors as well. It was error to not do so. I would reserve the rest of my time for rebuttal. Thank you, Your Honors.
Thank you. Rebuttal.
Thank you, Your Honors. First, I would like to say that in this case, it's important to look at what the standard of review is and who the burden lies with. In this case, the burden of disability is on the plaintiff. At the full commission and at the Court of Appeals level, the only factor that is in contention is what is known as the third prong, as Russell's, as articulated by Justice Irvin previously, and that is whether or not he is capable of some work, but due to pre-existing conditions, it would be futile for him to actually look for work. The Industrial Commission found at finding of fact 37 that he did not show that it would be pointless for him to look for work, and therefore they found there was no evidence. We believe that the record is complete with competent evidence to support that finding. If you look at the actual record at pages 132, he was specifically asked, do you think you can find a job today if you tried? And his response was simply, no, not picking up nothing above 20 pounds. I couldn't. So he limited to whether or not he could find something that was within his restrictions of picking up 20 pounds. Then when asked if he conducted any job search, the testimony is not in dispute. He said he did not look for work. He did not file an application with anyone. And his sole reason for not doing so is because by his own testimony, he said, I like who I'm working for. There's nothing in the record to show that he put forth any evidence that it was pointless for him to look for work because of age, because of experience, or because of his level of education. Those factors were found by the Industrial Commission, but the fact that they're in the opinion award does not necessarily mean that they lead to a finding of futility in this case. There's no connection to show that because of those factors, he cannot look for work. It appears in this case that Mr. Griffin is looking for job security. He wants to be able to work for the employer as he did for 2 years in a suitable job, then work for the employer in a job that he asked for, but at the same time say, just in case something happens, I want to be able to show that the job was not suitable or that I am temporarily disabled. I know it's not absolute when somebody shows wage earning capacity, but there are cases by this court that says that wage earning capacity when somebody does work is strong evidence that a person is not disabled, not conclusive, but is strong evidence. And in this case, he was able to work 2 years in the fabrication shop, working the same hours, earning the same wages. Then he has worked for the employer for the past almost 5 years at the same hours and the same wages, doing essentially the same thing he was doing in the fabrication shop by his own testimony. So we'll first say he has failed to prove disability, and that the Court of Appeals, if they followed the standard of review by simply looking at the findings and the fact and seeing whether there's competent evidence to support those findings, they should have reached the same conclusion as the full commission. You only get to the issue of suitability once plaintiff has shown that he's disabled. And as to the issue of suitability, again, there's competent evidence to support the findings of fact by the full commission. The job was not specifically created for Mr. Griffin. They showed that there was others that did the job before him and while he was doing the job. It's at the same comparable rate as others doing the same job. It was within his restrictions. He testified that he was able to do the job. The only factor that the Court of Appeals will contend is essential is whether or not it's available in the open market. The defendants will contend that looking at the reading of Peebles and Psalms, that question only comes into play if the job is so modified or if the job was specifically designed or created for that employee. Do you look to see would that person be able to get that same modified job in the open market? That's not the case here. Also, as to the issue of vocational rehabilitation is not applicable in this case because there's no evidence that Mr. Griffin in this case earned less than 75% of his wage earning capacity. Again, at both jobs that he performed after the compensable injury, he earned his same wages in the fabrication shop and in the job that he asked to do that he continues to do to this very day. So vocational rehabilitation under 97-32.2 is not applicable. And also as to the reasonable search, I believe at all levels, the Court of Appeals, as well as the full commission, came to the same conclusion for the same reasons. There's no evidence of any job search whatsoever, so there's no evidence that the job search could be reasonable. Mr. Griffin testified that he did not file an application, that he did not look for work for anyone else, and the reason why he did not do so is because he liked the work he was doing. Prior to the hearing, 3 weeks before, he and his wife looked online and compiled a list of like 5 jobs. So in 4 years, they're waiting until 3 weeks before the hearing to conduct some type of job search. That consisted of looking online at jobs that were beyond his work restriction. He looked at jobs that was consistent with the job he did prior to his injury. So he looked at pipe fitter jobs, jobs that everyone agreed in this case that he cannot do, that those jobs exceed his restrictions. So we would say it could not have been a reasonable job search to what, if you look at what he did, because A, he did not look at a job within his restrictions. B, he did it 3 weeks prior to the hearing, and he testified and agreed he solely did it for the purpose of the hearing. He was not looking for a job. So I think there's no evidence in this case, as the commission found and as the Court of Appeals affirmed, of a reasonable job search in this case. For the reasons that have been argued in our brief and for the arguments I've made today, we believe that if the appropriate standard of review is followed in this case, that the full commission decision should be upheld on all issues as to reasonableness of the job search, as to futility, and as to suitability, as indicated in the dissenting opinion of Judge Tyson. If there are any questions, I certainly thank all of you for your time today.
Thank you, counsel. Additional rebuttal? You'll need to unmute, Mr. Ayers.
Thank you, Your Honor. Mr. Griffin sat before the Industrial Commission and listened to his own employer testify that he wouldn't be considered for these jobs because of his physical limitations if they didn't already know him. That is job insecurity. Mr. Griffin's own employer wouldn't hire him. Where is the evidence that other employers would? The ultimate objective of the disability test, and this comes from Peoples versus Cone Mills at page 437, is to determine the wage that would have been paid in the open market under normal conditions to claimant as injured. Just because the employer offers a job does not mean that that job exists or is reflective of that employee's wage earning capacity. That cannot be the way we determine these cases. If all it takes is the employer to say, hey, we didn't create this job specifically for you, here it is, it's a real job, you know, that should not be an unrebuttable presumption that the job is real or it reflects that employee's earning capacity. It needs to be a job that Mr. Griffin can go out and find in the competitive marketplace. I would say that the standard of review issue, which is perhaps the most important one of this case, it's pretty clear. This was a conclusion of law that there was no evidence presented that plaintiff is capable of some work, but that seeking work would be futile. That's what the Industrial Commission concluded. This court, the Court of Appeals below, certainly is charged to review those conclusions of law de novo. The court can consider the matter anew and freely substitute its own judgment. The Court of Appeals correctly looked at the factors that this court has established for greater than 40 years: age, education, and experience, pre-existing conditions, and found these are exactly the types of factors that the Industrial Commission must make findings on. That they conclude there was no evidence shows they misapplied the law. Thank you, Your Honors.
Thank you. Thank you, counsel. Thank you, everyone. I will note for the record, as I indicated before we actually started live streaming this hearing, that Justice Berger was recused on the last case. That being said, Madam Clerk.
Oh yes, oh yes, oh yes. The Supreme Court of North Carolina will be in recess until 9:30 tomorrow morning. God save the state and this honorable court.
Thank you.
Thank you.